after conferring with the sponsor, whom I have learned to trust during the past few decades, including in our past several years of legislative work on human rights. After conferring with the sponsor, it is with deep regret that I must vote against his proposed measure amending the Human Security Act.
Matagal na po itong hinihintay ng ating kapulisan, kasundaluhan, and other state security forces.
Senate Number 1083, an act to prevent, prohibit, and penalize terrorism, thereby repealing Republic Act Number 9372, otherwise known as the Human Security Act of 2007. Roll call vote. Honorable Senators Angara, Binay, Cayetano, De Lima, De La Rosa, Drilon, Gatchalian, Go, Gordon, Hontiveros, Lacson, Lapid, Marcos, Pacquiao, Pangilinan, Pimentel, Po, Recto, Revilla, Tolentino, Villanueva, Villar, Zubiri, Senate President Soto III.
With 20 affirmative votes, 1 negative vote, no abstention, Senate Bill 1083 is approved in third reading. Senator Hontiveros recognized.
Thank you, Mr. President. I would just like to explain my, with all due respect, no vote on the Human Security Act.
Then the count should be 22, 19 affirmative votes and 2 negative votes. No, when I said 1 negative vote, it was recorded as Senator Pangilinan. So
yes,
you are now
Mr.
recorded
President.
as a second negative vote. Senator Hontiveros is recognized.
Thank you, Mr. President. I firmly believe that Congress should do all it can to ensure the safety and security of the Filipino people, particularly from acts of terror and other forms of violence. Acts of terror do more than destroy the lives of the people directly affected. They also lead to economic disruption and uncertainty, as well as an atmosphere of fear and paranoia. However, Mr. President, safety and security can never be at the expense of the fundamental freedoms guaranteed by our Constitution. While all rights permit exceptions, I fear that certain provisions of the bill, specifically those allowing the preliminary proscription of suspected terrorist organizations prior to their being given an opportunity to be heard, as well as those lowering the standard for warrantless arrest and detention, go too far and might lead to a number of pernicious consequences. As I premised in my interpellation, Mr. President, we must craft laws presuming the most despotic of implementers instead of the most benevolent of leaders. Thus, after conferring with the sponsor, whom I have learned to trust during the past few decades, including in our past several years of legislative work on human rights, after conferring with the sponsor, it is with deep regret that I must vote against his proposed measure amending the Human Security Act, a measure that I know is very important to him and that he sincerely believes will be supremely beneficial for Philippine society. I hope he understands that my convictions, as well as my faith in the fundamental freedoms enshrined in our Constitution, do not allow me to do otherwise. Marami pong salamat, Mr. President.
Senator Pangilinan is recognized.
Thank you. May I be allowed to explain my vote? Thank you, Mr. Chairman. Thank you, Mr. President. Mr. President, distinguished colleagues, first we thank Senator Ping Lacson for his diligence in shepherding this measure and for his patience in answering all our questions with regard to it. We recognize the hours of reading, research, and interviews that went in the crafting, sponsorship, and finally defense of the measure. However, this representation fears that the amendments to the Human Security Act right before us may be abused, as it will, among others, allow law enforcers or military personnel to place individuals and organizations under surveillance, compel telcos to divulge their calls and messages, arrest these people without warrant, and detain them for an extended period of 14 days. The measure also allows regional trial courts to outlaw an organization as terrorist at the requests of even foreign and supranational jurisdictions. It likewise removes the compensation for persons wrongfully detained. At a time when legitimate critics and democratic dissent are being attacked, the Human Security Act could be likened to a certain extent to the anti-subversion law during martial law and may be used against critics and opposition leaders. Certain questions now come to mind. Can the law be used against democratic opposition leaders? Can opposition political parties be outlawed and tagged as terrorist organizations? Some may say this is far-fetched, and most certainly some will say this is not the intent of the law. Allow me to bring us back in time during the martial law years to remind us of how the law was used to go after the democratic opposition leaders. The administration then claimed that it had declared martial law in response to the communist threat posed by the newly founded Communist Party of the Philippines and the sectarian rebellion of the Mindanao Independence Movement. Opposition figures of the time, including Senators Lorenzo Tañada, Jose W. Jokno, Jovito Salonga, Senator Ninoy Aquino, felt that the administration was exaggerating these threats, using them as a convenient excuse to consolidate power and extend its tenure beyond the 2 presidential terms by the 1935 Constitution. Allow us to further go back to a criminal case filed against opposition leader Senator Salonga, who at that time was Executive Vice President of the Liberal Party and eventually became its president, in the case of GR number L59524, dated February 18, 1985, against respondents, presiding judges, Quezon City, its fiscal, and 2 officers of the armed forces. These key facts I am to cite reinforce the well-founded fear of opposition leaders today of being persecuted under the Human Security Act. Given the current authoritarian climate we face and the well-grounded fear that it may be repeated. To cite some of the facts of that case, a series of bombings occurred in Metro Manila from August to October 1980. After a bombing incident on September 6, 1980, military and police authorities charged Philippine-born American citizen Victor Burns Lovely Jr. with subversion, illegal possession of explosives, and damage to property. Former Senator Salonga was implicated in these bombings because found in Mr. Lovely's possession were pictures taken in May 1980 at the party of former Congressman Raul Daza held at the latter's residence in Los Angeles, California, showing Senator Salonga and his wife with other guests, including Mr. Lovely. After another bombing incident in September 12, 1980, the brother of Mr. Lovely, Romeo, was presented in a television press conference, and in his interview, Romeo said that he had driven Mr. Lovely to Senator Salonga's house twice in 1980. Arrest, search, and seizure orders were issued against persons implicated by Mr. Lovely in the series of bombings. On October 21, 1980, military officials went to Senator Salonga's room at the Manila Medical Center to issue an ASO, which, however, did not specify the charges or charge against him. Senator Salonga's lawyers for some time were not permitted to visit him in the hospital room. On November 2, 1980, Senator Salonga was transferred against his objections to an isolation room without windows in an army prison camp at Fort Bonifacio. Senator Salonga was not informed why he was transferred and detained, nor was he ever investigated or questioned by any military or civil authority. On November 27, 1980, Senator Salonga was released from military custody and placed under house arrest, still without the benefit of any investigation or charges. After 4 months of being detained, charges for subversion, among others, were filed against Senator Salonga. All these while Senator Salonga had serious health problems. On March 6, 1981, and I quote the court records, Salonga was allowed to leave the country for, among other things, the possible removal of his left eye to save his right eye. It must be recalled that Senator Salonga almost died as one of the principal victims of the dastardly bombing of the Liberal Party rally at Plaza Miranda on August 20, 1971. To quote further from the records and the ruling of the court, Senator Salonga has limited use of his one remaining hand and arms, is completely blind in the left eye, and has scar-like formations in the remaining right eye. He is totally deaf in the right ear and partially deaf in the left ear. Further quoting the court records, our court records, Senator Salonga was arrested at the Manila Medical Center while hospitalized for bronchial asthma. When arrested, he was not informed of the nature of the charges against him. Neither was counsel allowed to talk to him until the Supreme Court intervened and issued an order directing that his lawyers be permitted to visit him. Only after 4 months of detention was Senator Salonga informed for the first time of the nature of the charges against him. After the preliminary investigation, Senator Salonga moved to dismiss the complaint, but it was denied. Supreme Court records in the case of Salonga versus Cruz-Paño, again, ruled in 1985, and I quote, "The respondents admit that no evidence was presented directly linking Petitioner Salonga to actual acts of violence or terrorism." And further quoting the court's ruling, "There is no proof of his direct participation in any overt acts of subversion. Guilt by visit or guilt by association theory is too tenuous a basis to conclude that Senator Salonga was a leader or mastermind of the bombings. He was indicted simply because some plotters masquerading as visitors have somehow met in his house." And court records on the testimony of Victor Lovely against Petitioner Salonga is full of inconsistencies, the court said. Senator Salonga and attorney Renato Tañada could not have whispered to one another because the petitioner is almost totally deaf, quoting from the ruling. Lovely could not have met Senator Salonga at the Manglapus Party in Washington, D.C. in 1977 because Senator Salonga left for the United States only in November of 1978. The pictures of Senator Salonga and Mr. Lovely at Raul Daza's birthday, to quote again the court ruling, in Los Angeles is not proof of conspiracy. Politicians have their photos taken with many people. Senator Salonga invoked the constitutionally protected right to life, liberty, and guaranteed by due process clause, alleging that no prima facie case has been established to warrant the filing of an information for subversion against him. The litany of lies and fabrications by the prosecution in that case revealed the extent of abuse of law enforcers inflicted upon an ailing opposition leader and former senator. Our fear with an administration that has jailed an incumbent senator on a case whose key witnesses are convicted drug lords, that has repeatedly warned about imposing martial law all over the country, that has in fact imposed martial law in Mindanao under what we continue to believe to be questionable constitutional grounds. These instances are more than simply déjà vu. They are more like foreboding. The proposed new definition of terrorism is vague and encompassing, making it open to abuse in that the simplest mobilization or common crimes can be framed by errant law enforcers as acts of terrorism. The prolonged detention is an impingement of rights and liberty. Why 14 days? If security officials and law enforcers are doing their job, why will it take them long to file a case? Or is the practice of arrest and detain now, produce or invent evidence later, still prevalent as it was when opposition leader Jovi Salonga was arrested, detained, and charged in 1981? The current law is not perfect, and we in Congress should be working continuously to make it work for the people. The amendments, however, are worrisome and could make the Human Security Act an even worse tool for repression instead of an instrument for thwarting terrorists. In closing, ang batas dapat proteksyon ng mamamayan. Proteksyon sa mga pagmamalabis at maling paggamit nito. Kaya kapag nagkamali sa pagpapatupad nito, dapat may managot para hindi na maulit, para hindi na abusuin ng batas, para hindi na pagmamalabisan ang karaniwang tao. Dahil sa karaniwang tao walang poder at walang kapit, maaring maging terror ang batas. Laws must be rights-based and must allow civil and political rights to flourish. Without respect for rights, there can never be security. Kung walang paggalang sa karapatan, walang seguridad. Respectfully, I vote no to the measure.
Majority Leader, Senator De La Rosa is recognized.
Mr. President, esteemed colleagues, I would like to extend my gratitude for your unwavering support in combating terrorism in the country. As I mentioned before, the enactment of this law will send a brave message to the world that we are in solidarity in the global fight against terrorism. I would like to extend my gratitude to our seasoned legislator and staunch ally against terror, Senator Panfilo Lacson, for shepherding and ensuring the swift but very deliberate passage of this legislative measure. This law will fully equip our law enforcers, not only in terms of weapons and funding, but as well protection of their right in the court of law. Matagal na po itong hinihintay ng ating kapulisan, kasundaluhan, and other state security forces. Mr. President, maraming salamat po.